3 of the Court of Appeals. I'm Judge Liz Harris. To my left is Judge Craig Welling. To my right is Judge John Webb. We have these nameplates in case you get mixed up. We have 2 cases on the docket this morning. The first is people in the interest of TB, and I see counsel are ready and experienced, but do you have any questions about how we're proceeding this morning? No. Just a couple quick things. For some reason, your phones actually have to be turned off, not just to silence. I have no idea why, but if you wouldn't mind turning your telephones off. It has something to do with the live streaming. And speaking of live streaming, just do keep in mind that we're using initials in this case, I guess because it started as a juvenile case. So we'll stick with initials then for the argument. 15 minutes per side, as you know, and you have rebuttal time, but you have to manage your own clock. And if there are no questions, then we are ready to go.
Thank you, Your Honor. May it please the court, counsel, my name is Gail Johnson, registration number 29703, and I represent TB in this appeal. I want to begin with a concession in the state's brief that I think impacts both of the important constitutional issues presented in this appeal, the due process issue and the 8th Amendment cruel and unusual punishment issue. And that concession is that under CSORA, TB's current level of risk to society is irrelevant or immaterial, as the people repeatedly state in their briefs. Sometimes they say irrelevant, sometimes they say immaterial. But that concession is relevant to both of these issues, because under the due process issue, what we have here is an irrebuttable, permanent presumption that there is a risk that he presents. And if you ask the state's attorney today, when TB is 100 years old, is he still going to have to register for something that happened when he was an 11-year-old child? The answer is going to be yes. And that is true regardless of what Judge Ashby found or Judge Woods or any other judge in the future could find. That is the statutory scheme we're talking about.
But they characterize this not as an irrebuttable presumption, but as an adjudicative fact that leads to a legislative determined outcome. In other words, the legislature determined that in order to qualify for deregistration, you can't have a subsequent adjudication. And the only fact that needs to be determined in order to determine whether or not he's ineligible for deregistration is that fact, has nothing to do with future dangerousness. How do you respond to that?
Well, first of all, their position is that the purpose of the statute is community safety. That's not a dispute that was the legislative stated purpose. But I would direct the court to the cases cited on our reply brief, pages 21 to 23. Vlandis versus Klein, Stanley versus Illinois, Bell versus Burson, and City and County of Denver versus Nielsen, because each of those cases finds a statute violative of the due process clause based on an irrebuttable presumption. And so if you do an analogy, for example, the United States Supreme Court's 1972 decision in Stanley versus Illinois. The issue there was a statute that said that if a father was unwed, his children would be removed from his custody. The court struck that down because the issue to be determined, that is certainly a very simple fact. Either he's unwed or he's unwed. But the court found, of course, that the purpose animating the statute is safety of children and what's in their best interest. And that using an irrebuttable presumption that being an unwed father makes you an unfit father is contrary to the due process clause. Unfair.
If we were to follow your irrebuttable presumption argument, is there a different outcome for adults versus juveniles? Because there's the same prohibition on deregistration for multiple convicted adults, right?
Yes.
So does this argument lead to the same result with respect to adult offenders?
Your Honor, I don't think that is the necessary consequence of a ruling in TB's favor on this point, and here is why. Because of the social science research regarding risk of recidivism for juvenile sex offenders, That whole body of research, which is discussed in the briefs, as well as the brief of amici, and again, is uncontested by the state, that's one reason why. Another reason why is because of the particularly strong facts on the record in this case, where we have detailed findings by Judge Ashby that TB had done the work he needed to do in treatment, and was no longer posing a risk to society.
And are irrebuttable presumptions per se unconstitutional, or is there just a strong disinclination for them? They're strongly disfavored.
They're strongly disfavored.
Okay.
Ms. Johnson, oh, I'm sorry.
Go ahead. No, go ahead.
I wanted to ask a couple other questions about the irrebuttable presumption. My understanding is that to invoke that doctrine and to get the remedy of a more individualized assessment, you have to identify a fundamental right, or there has to be some sort of a suspect classification going on. What's the fundamental right at issue in the case?
Your Honor, I believe that I'm not necessarily agreeing with the court's premise. And
Okay.
Let me back up to that if I could.
Okay.
I think we've raised 4 different ways we can win here. One is under the irrebuttable presumption doctrine, one is under an as-applied challenge, one is a straight-up fundamental fairness due process challenge, which is where the fundamental right doctrine comes in, and then finally under the 8th Amendment cruel and unusual punishment clause.
Okay, but I wanted to focus on this. It looks almost sort of like a freestanding irrebuttable presumption doctrine that you're relying on in the briefing. And now I can't remember the case. It's cited in your brief. It's a Colorado Supreme Court case that talks about, in order to invoke the doctrine and to get the remedy, some sort of heightened scrutiny has to apply, which means that there would be a fundamental right at issue. And so that's what I wanted to try to delve into a little. What is the fundamental right at issue?
A right to privacy, reputation. The record here also has property interest. The statute implicates property interest in terms of the fees that are required. All of these together. And when you put, again, this sort of, I think it's well documented, and that's discussed in the Miller case, but primarily if you look at the research and the amici brief and everything, what this statute does, it makes it harder for juveniles to rehabilitate. It casts them out from society in sort of a permanent way and says to them, we don't care about your rehabilitation. That is contrary to all of the recent jurisprudence from the U.S. Supreme Court, recognizing even if a juvenile commits a homicide, they are constitutionally entitled to meaningful review. And of course, this isn't a homicide, this isn't a criminal case, this isn't a homicide. But by analogy, again, to take someone who commits an act at age 11, who doesn't get the appropriate treatment, who then does get the appropriate treatment, the probation officer supports the request, all of that. So again, fundamental right to privacy, there's property rights of interest here.
Following that up, if I could, isn't the property right argument dependent on whether it's simply a fee or a fine? In other words, if the registration is simply a fee to defray the costs, doesn't that end the inquiry?
I don't believe it does, Your Honor, but perhaps I'm not following the court's distinction. But no one is calling it a criminal fine because their position is it's a collateral consequence and it's discussed as a fee.
Okay, well, if it's merely a fee that reasonably reflects the administrative cost, is that a property interest protected by the 14th Amendment?
I think to be sure it is. Again, he will have to pay these fees every year for the rest of his life. If he lives to be 100, he will be paying the annual fee 100 times, or 80 times.
So the administrative fee versus fine distinction is irrelevant to your 14th Amendment argument?
Yes.
Okay.
You referenced the literature that was cited by the amici as well as in your brief, and doesn't appear to be really contested about the difference between repeat juvenile offenders and repeat adult offenders. What is our role with respect to analyzing that? There are no findings from the trial court in this regard, right? So what do we do with that sitting in review when this hasn't been presented as part of an evidentiary proceeding below and had findings by the trial court?
Your Honor, I think the answer to that question would be more complicated if it were in any way contested by the people on appeal, but it is not. So therefore, I think this court can rely on it.
So we can just assume that under prong 1, for your irrebuttable presumption argument, that the presumption is not necessarily or universally true based on the literature that's cited in the briefing?
For one reason, based on the literature cited in the briefing. For a second reason, based on the particular record in this case with respect to the facts regarding TB's rehabilitation.
But that particular record is not relevant to your facial challenge, is it?
No,
Okay, so that's purely an as-applied consideration.
correct.
Does the state have an obligation to challenge secondary sources that were not made part of the record in the trial court?
I think they've had ample opportunity, including in the supplemental briefing, and they haven't done that.
Well, my question is a little different. Do they have an obligation to? I mean, this wasn't part of the evidentiary record.
I think they do, because getting back to Judge Welling's point, perhaps, if they had a concern about whether these studies had been adequately tested as a factual matter in the lower courts, they could have raised that point. They did not, and I think it's waived.
But that wasn't presented in the lower court. I mean, this was just presented as pure argument.
Right, I'm saying if they had that concern on appeal, then in their answer brief, they could have said, hey, this wasn't presented in the lower court, and we have the right to test it, so this court shouldn't rely on it. They haven't done that, they've just accepted it, because it's a well-established, consistent body of research that's, relied on by well-regarded organizations such as international human rights organizations like Human Rights Watch.
But not relied on by the legislature here, right? I mean, tacitly rejected by the legislature. The legislature's going off the apparent assumption that a recidivist juvenile offender poses a long-term risk, period, full stop. And why isn't that a reasonable legislative judgment? And what do we have to conclude in order to disregard that?
It's not reasonable because it takes away judicial discretion entirely. And that matters here when we have the record we have here, where the discretion and the findings, which again were unrebutted, uncontested, are all in favor of TB is completely rehabilitated and does not pose a risk. So, and let me get back to where I began, which is this concession by the state that his current level of risk is irrelevant and immaterial under the statute. That is a problem for them. That's a problem under the Due Process Clause. It's also a problem under the 8th Amendment, and I know my time is running down. I do want to save some for rebuttal, but just briefly on the 8th Amendment, the fact that his current level of risk under the statute is irrelevant or immaterial is one of the many things that makes this a punitive statute and why this court should find it punitive. And as this court knows, once you find it punitive, I think it's clear it's cruel and unusual. If I could save my remaining time for rebuttal. Thank you.
Good morning, Your Honors. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. Over the 17-plus years and more than a dozen published decisions, never mind the countless unpublished decisions from this court, not once has sex offender registration been found to be an element of a sentence or punitive in any respect.
Is there any Colorado Supreme Court case that has affirmed that conclusion of this court, or does it rest entirely on decisions of this court?
There are two responses to that, and the answer is yes, generally. The first one is people...
Yeah, I guess I forgot how I framed the question to know what yes means.
The answer is yes, the Colorado Supreme Court has weighed in.
Okay.
The first one, and it's cited in my brief, is People versus Birdsong, and that talks about the point of the statute is generally community safety and public safety and the notification process. And then it has repeatedly denied certiorari review in almost every one of the cases, which
Does that have precedential value?
No, it doesn't, but it shows that they agree with the court's decisions to the extent that they didn't need to review it further.
I'd love to believe that. Every time cert's denied, I should decide that they've agreed with me. I'm not sure I can go that far.
I'm not sure you can either, but we have Birdsong on top of that.
Okay.
On top of all that, we also have the U.S. Supreme Court weighing in Smith versus Doe, which is cited, I'm sure from your point of view, ad nauseum in my brief. And the reason that's cited so repeatedly is because it is binding, it is presidential. It reviews the federal, the Alaska statute under the federal Constitution, and it finds that it's not violative of the Eighth Amendment, it's not violative of substantive due process, it's not a punishment. And it could not be more clear in categorically rejecting those findings. And a number of divisions of the U.S. circuit courts have so found, including the 10th Circuit repeatedly, most recently in Shaw and Femdier, and both of those decisions address statutes that are in fact more extreme than Colorado's.
How so?
Well, in Shaw, for example, Utah has a much more stringent reporting requirement, has a much more stringent requirement for notification of the public. More information is disseminated. It requires a weekly or biweekly reporting requirement, and that the Circuit Court of Appeals here in the 10th Circuit found that that's not punitive. That doesn't rise to the level of being punitive. It has a number of unpublished decisions too. They're cited in the supplemental brief that I submitted last week in response to the Millard argument. And I would urge you that if this court even has an inkling of looking at Millard, that it should look at the 10th Circuit cases just to see just how far afield Millard did wander from established precedent, both in the 10th Circuit and the U.S. Supreme Court. Now, counsel presents a very compelling policy argument. She refers to a number of social science studies and faults me, of course, for not citing them in my brief. I didn't cite them in my brief because they were not introduced in the evidentiary hearing at trial, and this court is well aware, and our Supreme Court has mandated that evidence not introduced at trial below is not properly part of the record on appeal and is not part of a fact-finding function of this court.
But you didn't even raise that as an objection to us considering it. You just say it doesn't matter, not that we can't consider it. I mean, you didn't raise that argument in your briefing in response to those to that social science studies or social science evidence, did you?
It's not part of the record on appeal, Your Honor, so it wasn't necessary to even come to that point. All it establishes is a logical policy argument, the logic of which is to a different branch of government, quite frankly, and it's something that the legislature has already looked at in terms of when it first, back in 1991, enacted Colorado's Registration Act. And what it did at that time is it heard this policy argument and it drew a very specific line in the sand. It allows for the deregistration of certain offenders, but it says if you have a second offense, we don't want trial judges, we don't want juvenile courts making an individualized risk assessment or individualized determination. It's not that risk assessment or future dangerousness is immaterial or irrelevant. It's that the legislature already made that determination.
But isn't that, I'm
Go
sorry.
ahead. Go ahead.
No,
Go ahead.
no, go ahead.
What does Whole Women's Health do to that? So we have a legislative determination, or an implicit legislative determination, that there is a future recidivism risk. Now we have, at least put before us and not disputed, a whole host of unrefuted social science evidence that says, with respect to juveniles, this assumption isn't true. Didn't Whole Women's Health give the judiciary some authority to really look behind a legislative assumption if it doesn't rest on sound science, or if it's contrary to what the weight of the literature is? Didn't that kind of change the dynamic?
I think it had changed the understanding of what this court can look at, but it doesn't change the legislative policy determination and the fact that ultimately it is a legislative policy determination to make in the forthcoming legislative session. This court can see if there is counterweight, but again, this evidence hasn't been presented through the trial. The trial court didn't look at it, didn't consider it, and it wasn't ever argued below. So there's not a factual basis. There's not any sort of discussion points that can be merited. And I would point this court to the supplemental authority in brief that opposing counsel cited last week. And in the dissent, there's a line that says, social science has a role in judicial decision making, and it acknowledges that. But that role should be extremely limited, very limited is what it says. And it says, for the most part, the executive and legislative branches are the proper branches for the determination and resolution of social science. And I would urge this court not to go down that fact-finding path and not wade into what the literature says, because then you're going to have to go through all the literature and find the response to that literature and find and find the counterpoint. And that hasn't been presented either because it was never part of the record below. It was never part of the argument below.
It was argued below that juveniles are different. This was a feature of the argument and a basis. Though the trial court didn't take evidence, it was a basis and it was presented. But the trial court never needed to reach it because it thought it was bound, as it is. It's bound by our decisions.
True.
And so once it has to follow our decisions, it didn't have a role in getting into that. But if we were to say, no, it is punitive, but now you need to take a look at whether or not it's cruel and unusual, why shouldn't we remand this for a fuller hearing on that issue of cruel and unusual, or whether or not there's a reasonable basis for the legislative, the animating policy behind the statute?
Well, my first response would be to circle back to my primary argument in that this entire appeal is successive in the first instance. He had a 2010 appeal, a 2020 issue where this issue was squarely presented and squarely rejected.
Set successiveness
We'll
aside.
we'll set that aside, but I don't want to abandon that as an issue because that is the dispositive claim here. In response to your argument, you still then look at the...
It's a question, not an argument, but go ahead.
Sorry, my apologies. In response to your question, Your Honor, you still then look at whether or not it's cruel and unusual under the Eighth Amendment. And the first step of that, of course, is looking at what the purpose of the statute is. And it's unambiguous that the purpose of the statute is not punitive. It's community safety, it's community notification, and it's to aid in the law enforcement's investigative capacities.
But don't all of those purposes rely on the premise that there is a future risk?
No, Your Honor, they do not.
How don't they?
Because what goes into it is not just the assessment of the legislative intent, but also whether or not it is in fact punitive. And what we're not looking at is imposing a punishment. We're looking at collateral consequences. We're looking at the 7 Mendoza factors that you have to evaluate before you get to this idea of whether or not it's punitive in the first instance. So you have to look at the legislative explicit determination, which again is non-punitive. And part of that parcel and package might address the social sciences, but we don't get there in this case, and that's a policy question for the legislature to readdress this issue.
Well, let me pursue Judge Welling's question a little bit further. Focus just on his as-applied challenge. And I think we are bound by the lower court's finding that he poses no risk of recidivism because there's some evidence in the record to support it. So what purposes of lifetime sex offender registration survive the finding that there's no risk of recidivism here? As to him, not generally as to the population of sex offenders.
Well, I would first take umbrage a little bit with your determination that you're bound by the trial court's finding from the prior post-conviction motion that he bears no risk, because that wasn't a question, with all due respect, that was ever presented. The legislature's line drawing in the sand that I spoke about earlier drives this idea that we don't allow trial courts to make that determination. And if we were going to be making that determination, it would be a much more in-depth one than a judge looking briefly at a record. It would involve an evaluation. The Sex Offender Management Board would get to weigh in. It's not just about quickly looking and hearing from a probation officer who may or may not have seen the entirety of this particular registrant's ability to process. And the legislature made a very clear policy determination to say, we don't want these subsequent recidivist offenders to be able to deregister. It's not about the fact that they have a future dangerous, like habitual criminal statutes. It's premised on the fact that we have repeat behavior that's demonstrated this recidivism. And that's what we have here in terms of the as-applied challenge. We have this recidivism. We have this habitual criminal behavior. And it's not just that these are minor offenses, it's that the guilty pleas were a minor offense. In this particular case, this juvenile held down, vaginally raped with an associate, a 9-year-old special needs girl, and the original charges were 2 charges of sex assault. It's not that they're minor, it's that the legislature decided as a matter of policy, we don't want recidivists to have the opportunity to discontinue because we have made that policy determination of dangerousness.
Well, I mean, are you saying that the juvenile court essentially lacked jurisdiction to make findings that he poses no future risk of recidivism?
That is precisely what I'm saying, Your Honor. Yes.
Was that argued below? I mean, is it jurisdictional bar?
With the magic word jurisdiction, no, but the court did, the prosecutor did argue that this court doesn't have the authority to make that determination, is my recollection. And that would have been almost certainly the 2010 hearing in front of Judge Ashby.
But he was petitioning to deregister in 2 cases, and he was allowed to deregister in one of them, right?
Correct.
And his ability to deregister in the second one, the 2004 case, rested on a finding that he didn't pose a future risk, right?
It rested on the fact that he didn't pose a future risk and hadn't subsequently reoffended
Right.
after that case.
So the future risk issue was before Judge Ashby in that
The
in that
04
proceeding,
case.
in the 04 case, and she made that finding about the same juvenile at the same time, right? So it's not as though she was just making random findings that didn't have any bearing on an issue before her. That was an essential finding to an order she entered, right?
To the 04 registration
Right.
only, but that she did not have the jurisdiction or the authority to make that finding as this case.
But it's the same juvenile, same facts. I mean, you're saying that should be deferred to in the 04 case, but not in the 01 case?
The 04 case is procedurally different. There was no subsequent recidivist offense. I do want to talk very quickly about the due process and the Eighth Amendment issues. And I would urge this court that in Sacramento versus Lewis, the U.S. Supreme Court explicitly held that where a particular amendment, here the Eighth Amendment, provides an explicit textual source of constitutional challenges, that amendment and not general due process considerations guide the analysis. And so this court, as it found in the J.O. case and as it has found in a number of other cases, should simply find that it is not an Eighth Amendment violation of cruel and unusual punishment. I would rest on the analysis of the Mendoza-Martinez factors in the brief on that point. Regarding...
Can I ask you a quick question about those factors?
Yes, please.
Is there any guidance about whether some factors weigh more heavily or how we should balance all those factors?
There is, Your Honor. And very quickly, because my time is expiring, of course, the most significant factor is the relation to a non-punitive purpose. We know there's a non-punitive purpose here, first by legislative decree, but also because the U.S. Supreme Court and repeat divisions of the Circuit Court of Appeals in the 10th Circuit, as well as the 1st, 4th, 5th, 11th, and one other that I'm forgetting now, 6th, excuse me, and 9th as well, found that relation to a non-punitive purpose. The relationship is the connection to public safety. The relationship is the rational relationship is the connection to investigation.
But you're saying it doesn't matter, that public safety doesn't matter. You're saying his future dangerousness is immaterial and irrelevant. That's the disconnect I'm having a little trouble with.
With all due
So-
respect, public safety does matter, and that's what the U.S. Supreme Court has held, and that's what the 10th Circuit has held.
But no, I accept that public safety is a non-punitive purpose, but what you're saying is it's the 2 convictions or adjudications that matter, not future dangerousness, not whether or not the individual is likely to pose a threat to the community.
What I'm saying is the legislature has already made that policy determination. May I finish?
Sure,
I'm out of
thank
time. What I'm saying is the legislature has already made that policy determination about what is future dangerousness. The premise of this recidivism does implicate that future dangerousness consideration. And so the public safety aspect is tied to the recidivism aspect of this particular defendant. And that rational connection to public safety is the number one, the top relationship to the non-punitive purpose. It's not like a traditional form of punishment. It's not like an affirmative disability or restraint in any manner, shape, or form. The only factor that even comes close is whether it applies to a criminal conviction, which obviously it does.
Can I indulge
Sure, of
one?
course.
Are you conceding that that the Eighth Amendment protection of cruel and unusual punishment applies in juvenile adjudications. And it may seem like a question out of left field, but I came across this 1992 case that seems to indicate that the Eighth Amendment may not apply in adjudicative proceedings because it's exclusively for criminal proceedings. And it's People versus TSR 843 Pacific 2nd 105 from this court. You're not contesting that the Eighth Amendment doesn't, because this is an adjudicative proceeding, it's analyzed differently, are you?
No, and I think the U.S. Supreme Court line of cases in Graham and Roper and Montgomery, et cetera, have all sort of settled out on that. So I'm not contesting that. I am contesting that the Eighth Amendment wouldn't apply here because it's simply not punitive.
Okay.
If there are no further questions, I thank you for your time and ask that you affirm.
And I think we'll add whatever that time was onto Ms. Johnson's clock.
Minute 24, I think.
Thank you, Your Honor. Very briefly on the facts, to be clear, the adjudication at issue here for conduct when my client was 11 was for misdemeanor unlawful sexual contact, not the conduct that counsel recited, which were allegations, but that's not what is at issue in the adjudication. If I could return briefly to the questions regarding the fundamental right that's at issue here, I would direct the court's attention to Goss versus Lopez, which is cited in our briefs. It's a U.S. Supreme Court case from 1975. That's a case about temporary school suspensions. And if you follow the court's analysis, there is a discussion about an entitlement to education based on the law at issue there. But separately, the court then says, and this is at page, it's 419 U.S. at page 574, quote, "The Due Process Clause also forbids arbitrary deprivations of liberty, where a person's good name, reputation, honor, or integrity is at stake because of what the government is doing to him. The minimal requirements of the clause must be satisfied."
Isn't that superseded by the Connecticut Department of Social Services case where they expressly said that reputational interest does not trigger a due process inquiry?
I believe, Your Honor, if I'm remembering correctly, what the court says is reputational interest alone, but again, here we have other interests, including the property interest.
What in addition to the property interest?
I think we have the issue that this is a severe form of shaming and harm to reputation. This is a lifetime registration requirement that is unconnected to my client's current level of risk, subjects him to vigilante justice and all kinds of things. It is in the record here that it impacted his ability to get a better job and his ability to get housing. That is something that was discussed at the hearing before Judge Ashby. That is also supported by the social science research, which says my client's experience is very much in line with what juveniles on sex offender registries have generally experienced.
Are there any findings in that regard?
Your Honor, Judge Ashby did not make findings on this issue because she simply applied the statute.
Same with Judge Woods, right?
Yeah, Judge Woods, I don't recall that he made findings on that point. But again, I believe it is unrebutted facts in the record that he had trouble getting a better job and he had trouble getting housing. If I could then turn to the Eighth Amendment claim briefly, and counsel's argument that the Smith case puts this to rest. Smith said no such thing. Smith did not say now and forevermore every state statute that has sex offender registration is non-punitive. That's simply not what it says. And we know that as well because by my count, at least 7 states post-Smith have found sex offender registration statutes punitive and then gone on to apply the ex post facto or Eighth Amendment analysis.
And with some of them striking them down, but with most of them ultimately not striking them down, right?
There are some of each.
Right.
But on the core issue of whether it's punitive, New Hampshire, Oklahoma, Ohio, Indiana, Maine, Alaska, and most recently Iowa have all found that it's punitive post-Smith. That is absolutely allowable and this court can do that. There's nothing in Smith that precludes that. Finally, with my remaining minute and a half, I really want to emphasize that this is a matter of first impression under both of these constitutional issues. While there are previous divisions of this court that have addressed sex offender registration either generally for adults or in the context of juveniles, this court has never addressed these constitutional challenges to the mandatory, lifetime, permanent, irrebuttable presumption registration, again, in a context where the record shows my client is not a danger to the community.
Let me just ask a quick question on determination of punitiveness. The Kennedy case is an ex post facto case. Is the assessment of punitiveness for Eighth Amendment purposes any different than it is for ex post facto or for double jeopardy, or is it all one and the same?
I haven't thought about it in the double jeopardy context, to be honest, Your Honor.
Okay.
But in terms of the ex post facto punitive analysis and the Eighth Amendment cruel and unusual punishment punitive analysis, I believe it's the same.
Okay,
I'm not aware of any court that's held otherwise.
okay.
To the contrary, courts have often referred across those two doctrines.
Let me come back to your irrebuttable presumption argument. One of the purposes of lifetime registration is deterrence. How is deterrence more or less legitimized by future risk of recidivism?
Your Honor, I'm not sure that I'm understanding the question, but I think if the purpose is deterrence, that is a factor that makes it more like a criminal statute. Excuse me, I see my time has expired. May I continue to answer?
Of course.
I think when you start talking about deterrence, that is a foundational principle of criminal punishment and is one of the factors that would push this more towards the side of being found punitive.
Yeah, my question, though, is a little bit different. The legislature specifically refers to deterrence as one of the reasons for requiring lifetime registration. Deterrence is a real-time consequence of repeat offending. So how is deterrence dependent on an irrebuttable presumption of future recidivism?
I'm not sure it is, but once the court starts to find that the purpose and the only valid purpose is deterrence, then we're in the land where we win under the Eighth Amendment, because the government has not suggested otherwise. It's cruel and unusual punishment because under 43 other jurisdictions in this country, this would not be allowed for anyone, even under 14, a 13-year-old, an act committed cannot be subject to permanent lifetime registration.
Thank you.
Thank you.
Thank you.
Thank you to both counsel for your excellent arguments and your excellent briefing. The case is now submitted and an opinion will issue in due course. This is surprising. I thought everybody was here for the workers' comp case. So the second case is case number 2018-CA0565. That's Susan Burren versus the ICAO. Counsel are here, and I'm not sure, were you here when I made my few announcements before the other case? Okay. Okay, then I will just repeat that phones have to be turned off, not on silence. 15 minutes per side. You can manage your own clock. Whatever you want to reserve is fine. Any questions about the guidelines at all? No? Okay, so then whenever you're ready, I'm not trying to rush anybody, we are ready to go on this case. Oh, great, thank you.
Morning, Your Honors. I'm Roger Fraley. I represent Ms. Burren in this matter. This is a letdown from what you just talked about. It's a workers' comp case, and it is a matter of interpretation of a single statute, 842-107-8B, which talks about what do you do when the case comes to an end, basically, and you move on from treatment to evaluation of permanent impairment, if any. It's also a case of first impression. I can't find anything that talks about what do you do when there is no authorized treating physician, ATP, who has placed the claimant at maximum medical improvement. They get a 24-month IME, division IME, to rule on that matter, and the division IME doctor says, no, not at MMI either.
But there was an intervening step in there, and that was, I think, it was Dr. Ford, who was an independent, not a dime, but an independent medical examiner that drew a contrary conclusion that she was at MMI. And in fact, that's a prerequisite for getting even getting a 24-month dime, right?
Right. The 4 steps are you have to have 24 months, no ATP finding it at MMI, asking that and getting a no, and then having another doctor, which will generally be a non-division IME doctor, say, oh yes, that person is. So it's necessary. I think in the one case that you're talking about, I don't think that the doctor who kind of later in the process talked about MMI was an IME doctor. I think it was an ATP who basically changed his mind in that matter. I want to start with the legislative
Purpose?
Yes, thank you. Statute, which is 104102, quick and efficient delivery of benefits at a reasonable cost to the insurer or the employer without the need for any litigation. We're supposed to interpret these statutes to accomplish those things. And it's clear in most of the statutes that deal with this particular part when we're coming to the end of the process of treatment and going into evaluation, that there is a method for cutting down on litigation. One of the methods is putting a time limit. You have 30 days to react to a final admission of liability, to object to that. If there's already been a division IME, then you have the same period of time to go forward to try and overcome the division IME. Also, 20 days, 30 or 20 days for the other side, if they don't like what the division, an ATP says or a division IME doctor says. Also, they just have a strict or straight prohibition of initiating litigation unless an ATP has placed them at MMI, and that's what 842-107-8B1, and that has been in the statute since they were rewritten in 1991 when there's a wholesale change of the Colorado Workers' Compensation Act.
Counsel, can I ask you a quick question? So
Yeah.
it sounds like under your theory, what you're saying is if the treating physician says no MMI, and then 24 months goes by, and the employer says, well, I have a feeling that treating physician doesn't know what he's talking about. I want to have some independent person come in.
Right.
If that dime says no MMI, then that's it, you're done.
You have to wait until an ATP does it.
Okay, so is there a scenario, I mean, you talk about like, well, you could go and have your hearing. The employer could have a hearing and try to overcome the dime.
Right.
But that seems pointless because there's no, why would you do that? There's no remedy there.
Right, exactly right.
So essentially, under your theory, the employer gets one bite at the apple, and that is you get your independent physician in there. If the independent physician says, no, I'm with the treating physician, that's the end.
Right, you don't have anybody placing her the claimant, the injured worker at MMI, so you don't have a ticket to go ahead and get leave to have litigation on the matter.
But you do. I mean, you have, one of the prerequisites to getting a dime is that a physician other than the authorizing treating physician has determined that the employee has reached MMI. So before the dime is done, is even performed, you have conflicting doctors' opinions. You have an ATP that says no MMI, and you have some independent physician that says MMI. Then the dime comes in, and in this case, the dime happens to side with the ATP. Well, the provision that says how you overcome a dime opinion doesn't say that only the employee can object to the dime. It allows
doesn't say that.
either side to basically say, we think the dime is wrong, but we bear a heavy burden in that to establish it by clear and convincing evidence.
Correct.
And that's what happened here. You have the ATP, no MMI. You have the independent medical exam, not the dime, says MMI, Dr. Ford.
Right.
Then you have the dime that says no MMI. Now that you have the dime, you can go to hearing and try to overcome that dime. And why isn't that just, that's what the statute provides for?
Because it is hiring an outside doctor, not an ATP, to refute what the ATPs have said, that she's not at MMI.
Right.
And you couldn't do that under B1. Only an ATP could do it, and that was what the law was from 91 to 96, and there wasn't any claim that I can find where somebody said, oh no, that's unfair, that's violative of due process or equal protection, although they did get the 18-month and then the 24-month division IME passed.
Well,
sorry.
let me come back to what I think is implicit in my colleague's questions. Let me try to make it more explicit. So
Thank you.
the scenario is the ATP says no MMI. Employer hires an independent examiner who says MMI. That triggers a dime. The dime says no MMI. Then the employer, under the statute, can challenge the dime.
Right.
Okay, but if the employer succeeds in that challenge, and it just goes back to square one, which is the ATP says no MMI, and the ATP may maintain that position for years, what has the employer gained by challenging the dime?
Well, the overwhelming number of 24-month dimes do get a call of MMI, and only few get not MMI.
Well, but, and I would obviously defer to your practice in the field, but, I mean, you're making a statutory interpretation argument. My suggestion is that your statutory interpretation argument leads to the conclusion that, at least in some cases, and perhaps a small percentage of the cases, the employer can exercise its statutory right to challenge the dime, but gets nothing out of exercising that right because the employer is just then back stuck with the ATP.
Right. And
Well, does that make sense? I'm sorry if it's a harsh choice of words, but
That's fine.
is that a sensible way of interpreting a statute? To create a remedy that doesn't get anybody anywhere?
well, they didn't create this remedy for the 24-month division IME. They allowed division IMEs after the ATP has done, you could overcome those, but the overcoming the division IME was not designed to apply to a 24-month division IME. It's just that they added 24-month division IMEs after they'd written the statute.
So I'm sorry, can I just interject really quickly to clarify? So then you're saying Roman numeral 3 under here on oh boy, where are we? The section that talks about overcoming the dime,
Right.
that was always in the statute. That didn't come in with the 24-month rule.
It did not.
Okay.
It was in there, so you could always fight the division IME if, in the first 5 years of the statute, the ATP had placed him at MMI.
Okay.
I am not, if either the ATPs or the division IME places her at MMI, then the interpretation that the ICAO gave to this case is correct. I'm saying that there is one exception when nobody puts her at MMI except the outside doctor.
Where's the statutory authority for the dime to establish an MMI, to establish MMI and place a date on it? Because you're pointing us to Roman 1 that says it's the ATP that
Right.
determines MMI. Where's the statutory authority for the dime to make that determination?
I believe that's all part of the 842.107.2, which talks about what the division IME can or cannot do and how they're started. The reason I think that this is a bad interpretation of the law to allow them to overcome the division, the 24-month division IME, is because it leads to an absurd result. I don't have to go to a hypothetical about this. It's what happened here. The judge went on to find not only MMI, even though saying that I don't believe the division IME doctor is correct doesn't change it into he's saying that she's at MMI. It just takes him off the board. He's probably wrong. We're not going to consider his determination. But they still don't have a determination of MMI that I think the statute requires. And the absurd result is that my client could not put on any evidence about her permanent impairment, which is the next thing you do after MMI. And you can only do it if you've placed them at MMI. You cannot skip that step. And since the ATPs and the division IME doctor said not at MMI, they didn't rate her.
But there was a doctor in the mix that did determine MMI, and
Right.
it's necessary to have such a doctor.
Right.
So why isn't that sufficient?
Because if it was only a decision about MMI, that would have some greater weight, but it wasn't just a decision about MMI, it was a decision about MMI and rating, and my client could put on no evidence about the rating to refute the doctor outside the system, because you cannot get a rating from a doctor unless that doctor believes you're at MMI.
Did you ask for leave to get somebody to do rebuttal as far as the permanent disability rating?
No, because I didn't think the permanent disability rating was going to be part of the statute. I mean, part of the hearing, because it wasn't listed in the
But once you determine
Issues.
MMI, don't they go hand in glove that you have to then determine permanent disability?
you don't have to, but you may.
So
Some doctors put her at MMI and then send her off to somebody else to get a rating.
Well, is it your position that there was no evidence in the record on permanent impairment, or that there was evidence but your client, given the unusual procedural posture here, didn't have an opportunity to rebut that evidence?
That's correct, the second part. There was, Dr. Fall, who was the outside doctor,
Dr. Fall, not Ford. I kept referring to Ford. I meant Fall. I'm sorry.
It's been in the news.
I'm sorry.
Anyway, she said, at MMI, no permanent impairment. And that's the only one who did.
And the problem here is that if the treating physician had said MMI, and if that had triggered the dime, then the treating physician would also have come up with the impairment rating.
Correct, most likely.
So now there's no impairment rating from anybody other than Dr. Fall.
Right. And no ability of my client to get information that would rebut that, because all the doctors that she's dealing with have said not at MMI. I just think that that's a bad result. Makes it an absurd result, and makes the interpretation that the ICO gave this particular incident a bad one. It applies when either the ATPs or the division IME doctor say MMI, everything's fine. But this time, it wasn't fine because everybody said not at MMI.
Well,
Go ahead.
at the hearing to challenge the dime, the employer is relying on Dr. Fall.
Correct.
Would the claimant not have an opportunity at that hearing to present evidence of permanent impairment?
No, because her position is I'm not at MMI, and I can't get a rating unless I'm at an MMI.
Well,
I mean, arguing the alternative?
Yeah, well, okay, is there an interpretation that would allow, as the SCAO did, allow the ALJ to determine MMI, but require the ALJ, rather than going on and determining impairment, to remand for an or to convene an evidentiary hearing on impairment? I mean, would that solve your problem?
I can't think of any thing that prevents an ALJ from doing that, but that's not what happened here.
Did you request that?
No, Your Honor, because, again, the rating wasn't a written issue
Okay, understood.
in the application.
And I'm sorry, if you just indulge, follow up on that question. Isn't the risk that you're citing, which is not presenting evidence of permanent impairment, always at issue when the claimant is contesting MMI? They're coming in there, taking the position not at MMI. So let's say you had an ATP that said no MMI, a DIME that said MMI and no permanent impairment, and the employee wanted to overcome that. At the hearing, what you're presenting evidence of is we're trying to overcome the MMI. And if you lose there, well, you don't have anybody on your side again that gives you a permanent disability rating, because you put all of your eggs in the no MMI basket, which forecloses an alternate argument by at least that physician of a permanent rating, right?
Right, anybody who says not an MMI won't give a rating, can't give a rating.
So isn't that always inherent of taking the position of no MMI at a hearing?
If the division IME doctor said MMI, more than likely, well, I've never seen it not happen, they would go ahead and rate them.
Okay.
And then there's a rating, a call of MMI, and we're ready to litigate that. Thank you, Your Honor.
Thank you.
Good morning, Your Honor. Your Honors, my name is Michelle Carey, attorney registration number 27225. I'm here representing the employer, Destination Maternity, and insurance company, Liberty Mutual Insurance. May it please the court. The 24-month DIME provisions that we are here today discussing in 842-107-8B2, A through D, provide an exception to the general rule that an authorized treating physician has to make the finding of maximum medical improvement. In fact, when the statute was first presented as a bill in House Bill 96-1226, the introduction said, "This is an act concerning the right to request an IME upon the finding that an injured worker has not reached MMI in a workers' compensation case." In essence, then, it was absolutely enacted to allow the employer or insurer to have a chance, after a certain amount of time had gone by with continual treatments where the insurer or employer felt like it wasn't reasonable, the ATP was missing something, for whatever reason, it gave them an opportunity to attempt to bring the case to closure through the division IME process. There were certain requirements that we council discussed earlier. 24 months has to pass. You have to have something from a non-authorized treating physician saying the claimant has reached MMI. Then you have to go to the treating physician and say, do you agree? And if the treating physician still does not agree that the claimant is an MMI, at that point, the employer may request a division IME.
Okay, but you're relying on paren 2 of the statute. Is there anything in there that says at the end of this process, the ALJ steps into the shoes of the ATP and determines MMI?
Well, I think the statute provides for the division IME. Well, the division IME can step into the shoes of the ATP, for instance, because the division IME has statutory authority to make an initial finding of MMI or decide impairment.
Okay, but in the scenario that played out here, where the DIME said no MMI, then the employer challenges it, consistent with the statute. Is there anything in the statute, or I suppose for that matter in the legislative history, that says, and if the employer's challenge is successful, then the ALJ shall determine MMI?
Not using those exact words, Your Honor. However, what the statute provides, whether or not it's a 24-month dime or a regular dime, just treating physician says MMI and somebody wants to challenge that by going through the dime process. Once you get past the 24-month dime or the regular dime, and the dime occurs, and then that report is filed with the division, they are treated the same. And at that point, either party may attempt to overcome the findings of the division IME by clear and convincing evidence, thereby putting it into the hands of the ALJ. It's a hefty burden to overcome the division IME by clear and convincing evidence. But once that is done, and the statute, I will be clear, the statute does not say it becomes a fact question for the ALJ. That is what ICAP has said in numerous panel decisions. But by allowing either party to challenge the division IME, by overcoming it by clear and convincing evidence, it puts it squarely in the arena of the ALJ, I believe.
Can I, see, I'm having a little trouble with the actual language of subsection 3, though. Because subsection 3 says that if the independent medical examiner, selected under Roman numeral 2, finds MMI, then he'll also or she'll also determine the injured worker's permanent medical impairment rating. Then the next sentence says the finding of an IME can be overcome by clear and convincing evidence. To me, the finding might refer back to the finding that the injured worker has reached MMI, which sort of makes sense considering the history of the statute, that they plugged number 2 in there, the option that allows the employer to say, hey, I think something screwy is happening with the ATP. And they didn't fix 3. So 3 really goes with 1, and 2 is in there as some very limited exception for the employer. So if you just read the words in the statute, it sounds like the dime has to find IMM.
MMI.
Sorry, MMI, I'm sorry.
Your Honor, I believe the statute allows that either party may attempt to overcome any finding regarding MMI or impairment, not a finding of MMI or impairment.
Mm-hmm.
And I also believe that your concern about placing, was basically this 24-month dime provision, is it completely separate or is it part and parcel with the division IME process? I believe that if the legislature had wanted there to be an exclusion for, in other words, the employer could never overcome the 24-month dime finding of not at MMI, they would have said so.
Well, they sort of, I guess my thought is they sort of do say so, because what they require to keep going is a determination by the independent person that, in fact, you know what, employer, you were right. We don't know what's happening with that ATP, but this guy has reached MMI. And it doesn't seem absurd to me especially because they put in section 2 to sort of placate the employer. So the employer says, look, after 24 months, I would like to be able to determine whether or not there's something really shady happening with the ATP. So the legislature says, okay, here's what we're going to do for you. You didn't used to get this, but this is what we'll do for you. We'll let you come in, have a hearing in front of an independent person. First, though, you have to prove that this is not completely baseless. So we want you to put in some doctor's opinion. It can be your own doctor. Bring in your own doctor to say that the person's reached MMI. Then we'll let you have an independent review. But if the independent review says, no, the employee has not reached MMI, then we're done. That seems fine.
And isn't that supported by the structure of the second sentence, that the finding regarding maximum medical improvement and permanent medical impairment of an independent medical examiner in dispute under paragraph 2 may be overcome by clear and convincing evidence? You only have both MMI and permanent impairment if you have a dime that opines MMI. If you have a dime that opines not MMI, You don't have both of those. You can't.
Your Honor, I do think that the legislature didn't put in a specific exception saying only that you couldn't try to overcome the dime if there was not a finding of MMI. It's an extreme burden because, first of all, you're going to have to go to hearing and overcome that division IME by clear and convincing evidence. And you've also, quite frankly, don't have the authorized treating physician behind you either, right? So there is an already extremely heightened burden. It's a rare instance when this kind of confluence of facts happen, but it's not. I don't believe it is prevented by the statute.
But before, I'm sorry, I apologize for interrupting, but before this statute was put in place, the employer was even in a worse position because absent an ATP MMI finding, you were just stuck, right? So this does give you an out, but not a complete out if the dime disagrees with you. So I mean, it's better than it was before, but under their interpretation, it still leaves you in a box if neither the ATP nor the dime agree that there's MMI. Then you're in the same position as you were before, but there you were only relying on you could only rely on the ATP. Now at least you have a second bite at the apple. The question is, does it give you this sort of third bite? Is that I think that's the gravamen of Judge Harris's question.
Well, I think that if you can only, the one thing I would, first of all, to answer your question, yes, this puts us in a better position. This particular provision puts the employer in a better position than they were before. However, if you're going to read that only a finding regarding maximum medical improvement and permanent impairment may be disputed, you'd have to do it with cases where there's not a 24-month dime as well. So does that mean that a claimant could never, or just a regular division IME who says not at MMI, that couldn't be overcome? I don't think that's what the statute says. I don't believe that's what the cases hold. That's certainly not been ICAP's interpretation. In fact, ICAP has repeatedly said that basically there's this heightened burden. If somebody doesn't like what the division IME says, no matter what, MMI impairment, not just MMI and impairment, but if you just want to challenge MMI or you just want to challenge impairment and you want to go, you have to overcome it by clear and convincing evidence. But at that point, it becomes a fact question for the ALJ. And
what's the statutory basis for putting that in the ALJ's lap?
again, I believe that the statutory basis is when it was handed to, when the statute allows the challenge to go to hearing, to give that to the ALJ.
But every time they've vested somebody with the authority to determine to determine MMI, they've identified him in the statute. Originally, it was just the ATP could make that determination, right? And the employer was stuck with it. Now the statute allows for the DIME and authorizes the DIME to make that finding. But there's nobody else they didn't then authorize the ALJ to make that finding as a matter of fact if the DIME's opinion was overcome by clear and convincing evidence. They didn't close the loop on that.
Well, while the statute doesn't specifically state that, ICAP's interpretation is not specifically stated in the statute that only an ATP's MMI finding or impairment rating finding can be adopted. By allowing it to go to a hearing and allowing a fact finding, I do believe that they've put it back in the ALJ. And the ALJ has never been required, if you review the cases that where ICAP has espoused this view, they haven't been required to only adopt an impairment rating or an MMI date of an authorized treating physician. They have had the discretion to look at the record, and once it's just a fact question for the ALJ to look at it and decide for themselves what makes sense. And you'll see cases where they don't adopt necessarily the authorized treating physician, or they might adopt part of the division IME's opinion. It changes depending upon the specific facts of the case. I don't believe that the ICAP's interpretation prevents the claimant from receiving an impairment rating necessarily. While there were things that could have been done, in fact, when the division IME was concluded, the division wrote a letter to the parties. It's in the record at page 21 on January 21st, 17, saying if someone wants, telling the parties how to request a provisional rating, if they want an additional rating from the division IME, although he didn't give one, they can get one from the division IME by writing the division. Bring your own IME. You can ask the doctor, look, we're on your side, you're the treating physician. We agree she's not an MMI, but if she were, what would the rating be? And present that evidence. Present evidence as to why the respondent's doctor, if they believe the respondent's doctor was incorrect, why they were incorrect.
You said that's in a letter that went out to the parties?
Yes,
As part of the decision or prior to the hearing?
prior to the hearing.
Okay.
Yeah, that's Claimant's Exhibit 1, page 21 in the record.
Ms. Carey, another thing that occurred to me is if the statute were set up so that the employer was supposed to be able to overturn a decision that the employee had not reached MMI, why would you need the second step? So what you're saying is the employer gets, if there's no MMI found by the treating physician, the employer gets 2 bites at the apple. The employer gets to say, I'd like to have an independent person come in. Then when the independent person says, no, I agree with the ATP, then the employer gets a second bite at the apple. Why do you need the first bite at the apple if we think the employer gets to just have a hearing about whether or not the ATP is taking too long?
To make it a more difficult process. It's not an easy process.
But
I
you
don't
could
think.
to have the same burden of proof. That, I mean, you would say, come in and prove by clear and convincing evidence to this ALJ that the ATP is lollygagging and has got it wrong, that this person has hit MMI. Why couldn't you just say that?
I suppose the legislature could have set up the process that way. However, they have instituted the division IME process to attempt to give, someone who's not involved in the case, a review of the case. I see my time's up. May I conclude answering? To give a review of the case. And so it's part of this process that we have the division IME review to try to give another set of eyes. Again, if the employer wants to fight that, it makes it extremely hard. It's not easy. It's not going to be taken on lightly. And it doesn't happen a lot, but that doesn't mean that the legislature doesn't allow it to happen.
Thank you.
Thank you.
Thank you to both counsel. The case is submitted and we'll issue an opinion in due course. That's the end of our docket, so we are in recess.
All rise. Court will be in recess